Good morning. My name is attorney Brenton Begley. I'm an attorney and partner with McIntyre Elder Law. I'm joined today by Samantha Gordon, an associate in our office. Say hello to everyone, Samantha.
Good morning.
Good morning. So today we're talking about something very important, which is asset recovery, specifically Medicaid asset recovery. So the question is if you receive a benefit to help pay for long-term care, if a loved one receives a benefit to pay for long-term care through Medicaid, can they come back and take the property that they let you or your spouse keep? Okay, so the answer is yes, okay, if you don't pre-plan. But you need to know a little bit of background before we really jump into this. So when it comes to Medicaid asset protection, you first have to understand that you can keep assets and qualify for a benefit to help you pay for long-term care. So especially if you have a spouse, you're allowed to have, real property, a home, depending on the level of care that you need. You could have multiple pieces of real property. You can own life insurance up to a certain amount of money in the applicant's name, and the spouse can own a bunch of stuff. There's something called the Community Spouse Resource Allowance. Basically, in English, what that means is that if a spouse is not going into care and one of the spouses is the spouse that is not going into care, what we'll call the healthy spouse, can own quite a bit of money and property in their name. That won't count against the applicant. So this is all well and good. These are useful things to know for qualification purposes, but it's also useful to know that if you ever do receive care, you can keep assets, and those assets may be subject to Medicaid estate recovery in the future. So what we're talking about today is how to protect the assets that you can keep and qualify for Medicaid from Medicaid's ability to claw that back at a certain point. So Sam, when can Medicaid or any other creditor for that matter go after, an estate in North Carolina?
So when someone passes away, they have the right under North Carolina law to attach a lien to someone's probate estate, which probate's the ugly court proceeding that you have to go through the courts to have your assets distributed. And, they can do that at any point when you have your estate open. They could even open up your estate for the purposes of placing a lien against your probate estate, which we unfortunately see very often.
Okay, so if I heard you correctly, what you're saying is if, let's say someone receives Medicaid, okay? Let's call her Sally. Sally receives Medicaid, and she gets Medicaid to pay $400,000 for her stay between the time that she goes in and 4 years later when she passes away. So Medicaid can recover from any of the assets going through her probate estate after she dies. So she first has to die for Medicaid to be able to recover anything, right?
Correct. Mm-hmm.
After that, they can only go after assets that are subject to the probate process. So either going through probate or within the probate court's jurisdiction.
Correct. So, for example, real estate isn't necessarily a part of the probate estate unless it needs to be brought into the estate. So if there's a lien from Medicaid that's attached to a probate estate and the only asset is real property, which would be, say, your primary residence, your home that you work so hard for, they can actually bring that property into your estate, force a sale of it to pay their lien.
Right. So if Medicaid wants their, money back, which I'm sure they do, what they're going to do is just put a lien against the estate, and whatever flows through the estate or whatever the estate has jurisdiction over, it falls within that, ability for them to recover from that lien.
Yep. Unfortunately, it's terrible.
Right. So in the probate court's not going to close the estate with that lien hanging over that probate estate, and if there's assets flowing through.
Correct.
What about the heirs? I mean, do the heirs not get the asset before the creditor does? Does the creditor have priority over the heirs?
Well, I mean, there's plenty of ways that you can pre-plan to ensure that your heirs do get the property prior to that ever happening, prior to a lien being attached, which would be through doing estate planning.
Gotcha. So there's ways to avoid it, but essentially, if we're looking at, because the thought may come up, hey, you have heirs of an estate. Do the heirs not get paid their share first? And the answer is no. If there's a creditor, has made a claim against the estate, a legitimate claim against the estate. Now there's classifications of creditors, and Medicaid is low on the list, but they come before the heirs do. But luckily, as you're getting to, North Carolina is what's called a limited recovery state, which means that if we keep assets out of probate or the jurisdiction of the probate court, those assets pass free of any liens by a creditor, including Medicaid.
Yes. One great way to do that is something called a ladybird deed, which is also known as an enhanced life estate deed. So what that does is you get on this government benefit, long-term care Medicaid, that pays for your skilled nursing care. And you're eligible, you're on that benefit, you pass away. As we've stated, they can attach a lien to your probate estate. And if you have a house that's hanging out over here, they can actually force that house into the probate estate to sell it. So what the ladybird deed is, it puts a shield over that house, and it says that I own my house while I'm alive, but the second that I pass away, by virtue of the language in that deed, that property is gifted to who I have listed on that deed, which means that at the time of your death, it's no longer in your name, which means it would not be brought into the probate estate and not subject to that lien. So that deed, the ladybird deed, is a very cost-effective way to protect the home, the primary residence.
Gotcha. So what you want to do with that home, I mean, you probably put a lot of money into that home over the years, especially if you pay down a 30-year mortgage. That's like, 80 times more than the property, what it costs with the interest rate and everything you're paying. No, but you buy a house for $300,000, you probably end up paying $500,000 over time plus interest on that house. So put a lot of money into it. It's probably one of your main assets that you either want to leave behind for a loved one, including a spouse, or other family members, to give them some type of inheritance, preserve that. And so, a lot of people are looking to preserve the home. So what you're saying is that you have this tool that can keep this property out of probate without giving up either your control over the property or your ownership interest in the property. And I think that's very important, because what a lot of people end up doing is they know that they need to avoid probate. They know they need to protect the home, but they go about it in a different way. Right? Like they just give their home to their child right now. So, would you recommend someone just transferring ownership interest in their home to their children in lieu of doing something else?
No, I mean, there's multiple reasons why you don't want to do that. Number one, if your child owns your property, they could kick you out if they want to, because they own the property. Number two, if they have any type of creditors, if they have any type of liability situations, like if they're getting sued or if they're going through a divorce, that asset is now theirs. So it could be subject to anything that's going on in their life. In addition to that, your children would be the ones that are responsible for, the taxes on the house. And if they can't pay that and they're not paying it, then that house can go into foreclosure if you're not aware of what's going on. So there's multiple reasons why you would not want to do that. And there's other avenues in which you can really make sure that your house is protected, such as a ladybird deed or maybe a trust. But with a trust, in this specific situation, you want to make sure that you're doing that. You're pre-planning, because there's a certain time frame in which you'd want to set up a trust for purposes of preserving your assets for a long-term care Medicaid.
Gotcha. So the time frame you're talking about is the look back period for Medicaid, which is a scary thing that a lot of people are freaked out about, trying to avoid triggering that look back period. But we can really turn that around, do a little bit of legal jujitsu, and use that to our benefit in our pre-planning to go ahead and get that look back period started, to get past it quicker. Because the sooner you trigger that look back period, the sooner you get the clock ticking, the sooner you're past that period. So that's a good planning tool. Planning with trust can be very useful. Certainly a ladybird deed is a good tool. Let's answer probably a question that folks could be screaming at the screen or at their speakers right now is, does the ladybird deed trigger that look back period?
No, it is not affected by the look back period.
Gotcha. And one of the reasons why a trust helps you protect those assets in the same way that a ladybird deed does is the trust helps you avoid probate with all the assets that you put into it, right?
Correct. Yep.
What about a will?
A will?
Yeah.
So a will, it's not going to be as effective because what a trust is, it's a legal vehicle in which you can put your assets into a pot and you have a trustee, someone that's going to manage that pot for you. And it's all done in private. It's all done outside of probate. Whereas a will, if you have an executor name that's managing your assets and your assets are being distributed outright to your heirs, and there are bank accounts, there are, properties that possibly need to go through your will to transfer to your heirs, that's all possibly subject to your probate estate. So you're not avoiding protecting your assets at that point, whereas a trust would be a great way to do that.
Right. So a will is a guide through the probate process. You're not avoiding probate by having a will in place. While it's a good thing to have just in case you do go through probate, we should endeavor to avoid the probate process entirely. And we can do so with some type of pre-planning and utilizing tools like trust and ladybird deed.
Yeah. And if you're thinking about long-term care, what I always ask our clients is, what does long-term care actually look like to you? Because that's really going to determine what type of estate plan we do as well. Like, are you concerned about having to go on a long-term care benefit to pay for skilled nursing? Are you planning on using your own assets? Are you planning on not going to one at all? Like, what actually does long-term care mean? Because that's really going to help guide us as your attorneys to really understand what kind of estate plan we need to craft for you to fulfill your goals, but also make sure that things are done in such a way that your family isn't burdened by what they need to do for you after you pass away.
Yeah, and that brings up a good point of why folks should be worried about this. I mean, over 70% of individuals will need some type of long-term care at some point in their lives. And given that statistic and that likelihood, it's important to understand that long-term care costs hundreds of thousands of dollars a year, tens of thousands of dollars a month potentially. And so that's where a lot of people end up losing a lot of money and property that they've worked hard for their whole lives and want to pass along to the next generation, to a loved one or to a spouse. And so what we help people do is navigate that situation, help pay for the care, and at the same time do so in a way that prevents them from sacrificing their assets through this probate process to the government to recover what was paid out. So this has been a good discussion, Sam. It's my understanding there's a lot of tools to help protect and preserve assets. The sooner you plan, the better, right?
Definitely. Pre-planning is key.
And that helps us decide what tools we can put in place to make sure that you can just kind of sit back and forget about the worry as far as whether your assets will end up, being recovered in a state recovery situation or subject to being counted against you and trying to qualify for care. So thanks again, Sam. This has been the Elder Law Report. I would offer a free consult to anyone who has any interest in helping protect their assets, preserve those assets, or qualify for a benefit to pay for long-term care. You can visit our website, www.mcelderlaw.com, for a free consultation. Thanks again, Sam. See you guys.
Bye.